Hey everyone, we've got a special review today of AI contracts. There's obviously a lot of buzz in the world today about artificial intelligence and what it can and can't do. And we thought because we're getting so many contracts from clients that where they've used AI and told us, hey, improve on this or use this as a first draft, we want to make sure that our clients and listeners are understanding what you get when you ask AI to draft a contract and what the difference is between AI and what a lawyer does today, just so there's no dispute or confusion about the difference in the quality and analysis that you get when you hire a lawyer versus what you get with AI. Not to say AI is bad. There's a lot of great elements to AI, and it's a great start for a lot of contracts and even just thinking through agreements. But we wanted to show you guys today what an AI contract looks like and also what a contract that we work on looks like and help you understand the differences and maybe some terms you want to look out for when you're drafting a contract. So we got Sahil with us today, who's going to help walk us through a private label manufacturing agreement and show you guys what exactly you get when you start with AI and what you get when you will finish with us. Sahil, take away.
Yeah, thank you, Pankaj. I think you're right. This is a very prevalent issue right now where AI is good enough to be dangerous. So far, we have received a number of agreements where clients will send us a draft using ChatGPT, for example. But the problem with that is there are a lot of complexities around business transactions that come from having experience with these agreements. And also, you need to know what the statutes are, what the law says, and also you need to have experience when it comes to drafting in terms of what can go wrong when you are working through an agreement. Additionally, there's an understanding that we have of how money and risk flow in certain transactions that can get lost when you're doing a ChatGPT draft of an agreement. So what we're going to do is we're going to run an experiment. We have here a private label manufacturing agreement that we drafted. This is an agreement that we use as a precedent. So this is something that we've drafted at Carbon Law, and it serves as a basis for our conversations around private label manufacturing agreements. We're going to compare a Carbon Law Group manufacturing agreement precedent with what ChatGPT would draft with the same title. So we're going to type that in here. We're going to say draft a private label manufacturing agreement. Let's see what you got. Okay, so if we start from the top, so far so good. We've got the names of the parties. We have a manufacturer and a brand owner. So that shows some understanding that this is an agreement between a brand and a manufacturer. Now, as we keep going down, we hit our first problem, which are products. The manufacturer shall manufacture the following products: list of products with specifications, packaging and labeling in accordance with brand owner specifications. Detailed specifications, quality standards, and packaging requirements are set forth in Schedule A. Now, here's something that we anticipate in our agreement. Before we even get to products, in our agreement, we start with the terms of manufacturing, which essentially express that this agreement is going to be accompanied by statements of work that document the specific products that are going to be created. This gives flexibility for broad agreement on broad terms, but allows also for you to get specific with the statement of work in terms of the variety of products that can be produced and also different conditions and situations that might affect a specific statement of work. So we get into, after the terms of manufacturing, we get into materials. This ChatGPT agreement right off the bat ignores that there may be raw materials involved that are sourced from other parties. And so we want to first take into account that there could be multiple sources of materials, whether sourced through a subcontractor or oftentimes the customer is providing some customer sourced materials. So that's the first issue we want to highlight when it comes to products. Now, the next component here we get to are purchase orders. All purchases of products shall be made pursuant to written purchase orders submitted by the brand owner. The manufacturer shall confirm all purchase orders in writing within X days of receipt. Lead time for delivery shall be X days from the date of order confirmation unless otherwise agreed. Now, here's an issue. We understand that our clients, especially our manufacturing clients, manufacturing clients and the brand typically want to have some kind of a pre-production sample that gets approved. it's very risky to go into bulk production without having a pre-production sample.
So true.
So
Depending, especially like on all types of things you're manufacturing, right? Whether it comes to be garments or we work with cosmetics, right? All these types of issues. What could be a widget, right? You want to make sure that's approved, the sample's approved before they go to full production.
that's exactly right. And like you said, it could be garments, it could be skincare, it could be cosmetics, but there needs to be some meeting of the minds between the brand owner and between the manufacturer at each stage of risk. So you need to create checkpoints in your private label agreement right before your client, in this case, let's say the manufacturer, is exposed to a large amount of risk. In fact, both of them, once you go into bulk production, they're both exposed to a large amount of risk because once the production is done, there's nothing you can do. You can't rewind. Once it's done, the costs have been incurred and there's no way to go around that. So next we get into pricing and payment. Now, it's easy to just place in here that payment terms are 50% deposit upon order, 50% upon delivery, net 30 days after delivery. But how do we know exactly what the costs are that are being incurred by the manufacturer in terms of risk, in terms of how risk is allocated between the buyer and the seller? We need to know what is the basis for the deposit. A deposit could be 50%, it could be 35%, it could be 20%. It could be that a manufacturer needs the full payment and then is willing to accept payment prior to shipping.
Yeah. And
Yeah.
this is a really good point, Sal, because for me it also highlights the fact that it really depends also who you're representing, right? We're going to
Right.
argue different terms depending on if we're representing the manufacturer or the buyer of these products, because there are very different interests that these parties have.
That's right. And in fact, the next point that we have, this point C, talking about all prices are inclusive or exclusive of applicable taxes, duties, and shipping charges. That's great to highlight. But now what do we do with that? For example, in this tariff environment, let's say you're a country that one of the raw materials is sourced from is subject to a tariff. And let's say the brand put the production in before the tariff rate increased. Is there any room for an automatic increase of the price on the side of the manufacturer? Or are they stuck with their original price? And on the flip side, if the manufacturer runs into trouble where the tariff rate has now skyrocketed the price, and now the manufacturer is demanding the balance payment from the customer, both of the parties could get stuck. So these are terms that we need to have negotiated. It's not just as simple as plugging in a sentence like this, all prices are inclusive or exclusive of taxes, duties, and shipping charges. We need to think through, how do we bake in that risk of variable pricing in a manufacturing situation, especially in a dynamic tariff environment like we're in. Then we get into labeling and intellectual property. So in this case, this agreement says the brand owner shall retain all rights to its trademark, trade names, and product designs. Manufacturers granted a limited, non-exclusive license to use brand owners' marks solely for the purpose of manufacturing and packaging products. Manufacturers shall not sell or distribute any products bearing brand owners' branding to third parties without consent. In this case, if we look at the levels of IP protection that are involved in an agreement like this, we start with the grant of license or assignment of IP. In our case, the manufacturer is granting to the customer a limited, non-transferable, and non-exclusive license to use any IP necessary to produce the products for customers' private label. However, we also bake into this agreement a provision for the manufacturer to own the IP when it comes to the product design, which the brand is going to then license. So either we need to be able to explore how risk and money flow and how IP flows. For example, if the brand owner is bringing the IP to the manufacturer, that's one thing. And the IP comes in multiple forms. We have trademarks. We also have artwork for labels. But what about who's developing the formula? The manufacturer might be developing the formula, or the brand might be developing the formula. In this case, for example, where we're representing our client, the manufacturer is developing the formula and has baked in a buyout or a minimum purchase obligation in order to have the IP transferred. So that's a nuance that can't be taken into account when it comes to a draft like this from ChatGPT. Then we get into quality control. Manufacturers shall comply with quality standards and regulatory requirements applicable in the target market. Brand owner reserves the right to inspect facilities and audit quality control processes. This is a big problem because when it comes to quality control, what we're dealing with is very subjective standards at times. What if we're talking about regulatory requirements applicable in the target market? That is a very broad, abstract concept, and we need to pin this down, pin approval and quality control to something that both the parties can agree upon in a very clear and obvious way. And so what we've done in our agreement, we've baked in what's called product acceptance. At each major stage of the sampling process, the manufacturer provides samples for the customer to inspect and test. The customer must conduct the necessary testing and inspection within 24 hours of receiving the samples and provide written approvals for the samples received within 48 hours. This written type of understanding on the exact product allows for both parties to see that this is what quality means. Quality is not an objective standard necessarily. Oftentimes, quality is subjective. And as attorneys for these types of transactions, we're aware of that. Next, if we get into warranties, in this case, we have manufacturer warrants that the products shall conform to the agreed specifications, be free from defects in material and workmanship, be manufactured in accordance with applicable laws and regulations. Brand owner warrants that it owns or has rights to the trademarks and product formulations. We've talked about how that might not be the case. Sometimes the manufacturer is the one with the product formulation. But even if we just look at the warranty itself, we look at our warranty. We have a very robust warranty here. First of all, where the manufacturer warrants that it will manufacture the products in a good, professional, and workmanlike manner. And then we have a specific time period. The manufacturer cannot offer a warranty for an indefinite, unlimited period of time. So in this case, we have a period of 6 months, which is the warranty period. So manufacturer warrants that the products will materially conform to the specifications and quality control standards in the statement of work. And luckily, in our agreement, we would have clarified what the specification and quality control standards are based on the original sample. Now we've also limited the exposure of risk for the manufacturer, and we've clarified how long this policy lasts for the customer. If we continue on with our warranties, we also clarifying that the foregoing warranties are in lieu of all other warranties expressed or implied. The law implies certain warranties, the warranty of merchantability, the warranty of fitness for a particular purpose. So in our case, because we're representing the manufacturer, we want to limit the scope of this warranty as much as we can under the applicable laws. You are permitted in California and under the laws that we are subject to when it comes to these types of agreements between merchants. We are able to contract for a lot, and that allows for a lot of creativity that a ChatGPT, for example, is not able to necessarily anticipate. For example, we want to waive certain types of implied warranties, and we're able to do that if we express them in contract. But if we don't, we're leaving those on the table and we're leaving our client exposed.
Yeah, absolutely.
And also, this is subject to manufacturer's warranty of any product is of no effect if the product is not stored or handled appropriately after delivery. So that way we're protecting the manufacturer, and we're also clarifying to the brand owner, yes, we're offering a warranty, but these need to be handled in a commercially reasonable way. The products need to be handled in a commercially reasonable way. If we continue on, we've included a section related to product recall. When you're dealing with mass production, this is a very important provision that is totally left out of this draft. In the event of a recall of any product, the parties shall cooperate in good faith to carry out all reasonable corrections. And we need to split the risk. Manufacturer is only responsible for the costs associated with the recall to the extent the root cause of the recall is directly and solely attributable to a defect in the manufacturing process. We can't have the manufacturer blamed for or liable for acts of the brand that the manufacturer had no control over, and vice versa. The manufacturer in this case is taking ownership over the manufacturing process, but we need to slice those two levels of liability. And that's another place that we come in is how do we limit liability? Now, if we continue on and we go into confidentiality, so this is, you've got a one sentence confidentiality provision here that each party agrees to maintain the confidentiality of any proprietary or confidential information disclosed during the term of this agreement and not to use or disclose such information except as permitted under this agreement. Well, that's very broad, and it doesn't really take into account the circumstances that could arise. So, for example, in our confidentiality provision, we are defining confidential information, first of all, as all non-public information of a party disclosed to the other party, and that the disclosing party designates as being confidential, or which under the circumstances of disclosure reasonably ought to be treated as confidential, including but not limited to formulas, business plans, marketing plans, and product ideas, as well as prototypes, samples, materials, and the like. This is a major problem with the ChatGPT version of this provision. How do we define confidentiality?
It's a
We
big
need to,
question. Yeah,
yeah,
you need to have a definition for confidential information.
exactly. If we continue on to term and termination, we have this agreement shall commence on the effective date. Either party may terminate within X number of days. Termination for cause may occur immediately upon material breach not cured. Okay, now either party may terminate this agreement. The question then becomes, what do we do if the termination occurs in the middle of production? Are we dealing with the cost of raw materials? How are we dealing with the IP? If the manufacturer has designed IP, has developed IP, and this brand is no longer taking that IP on, can the manufacturer license the IP that they've developed for other clients? There are a lot of questions here that we need to answer. The effective termination. So we have a whole section here related to the effective termination, how the IP is handled, how raw materials are handled, how leftover packaging components are handled. For example, here we talk about the licenses. Upon the termination of this agreement, the rights and licenses granted to manufacturer pursuant to this agreement, including the right to use the IP and manufacture the products, will automatically terminate. Now, in this case, the brand may be providing the IP, but in the case the manufacturer is providing the IP, we need to contract around that. A termination is not simply a termination. There are leftover costs, there are leftover rights that need to be addressed.
So interesting, Sahil. And also, I'm thinking ChatGPT doesn't really address at all how to de-risk this deal, right?
That's right.
If you're the manufacturer, maybe you're going to ask for payments and milestones, right? Maybe you ask for payments over every month, based on milestones, or every 6 weeks or 8 weeks based on how, where you are in the process. So you never get too far behind. Because one thing we've discussed in the past is that, clients can really be underwater a lot of money and invest a lot of money in production, especially manufacturers fronting a lot of fees for cost of goods and all these other raw materials. And then a client just disappears, or something happens, they change their mind. We've seen it all. And now we have problems, or they're just holding back money just because they're trying to strong arm the manufacturer. And, we've seen all these situations and they've become ugly. So maybe to de-risk that, it's really getting payments at a certain milestone so you're never too far behind or too underwater on some of these deals.
I think that's exactly right. As advisors to our clients, we have the experience to know what are the potential risk points? What are the potential places where you could lose money, where things can go wrong? And that's something that you're not able to anticipate, or that's not something that ChatGPT is able to customize, because on its own, it doesn't know what to ask. So if you're a non-lawyer and you're using ChatGPT and you're just typing in a private label manufacturing agreement, you are not going to know that you have a lot of option to deal with risk and to deal with payments and to deal with money. You might be getting a option, but it's not necessarily the best option. So we've kind of come to the end of this agreement, but you can see that our agreement continues on, and we have indemnification provisions. Who's responsible when there's a lawsuit? If the lawsuit is against the brand or the manufacturer, who's paying for that lawsuit? And we have to break out what are the specific situations where one party pays versus another. We have provisions related to default payment obligation. We have other provisions related to authorized disclosures, non-solicitation. These two parties are engaging with each other. Now, what if one party, the manufacturer, decides it wants to hire a person from the brand who's working with them to create this product, or vice versa? Or either party decides to take the other party's IP or this product and take it to a different party? How do we deal with that? We have force majeure provisions. We have insurance provisions about these parties need to maintain, customer and manufacturer agree to maintain appropriate insurance levels, cover their respective risk under this agreement. So we continue on with provisions that we know are necessary. One important provision is related to dispute resolution. In the event there's a dispute between manufacturer and customer, in this case, we've drafted a JAMS provision for comprehensive arbitration for both parties. This saves both the parties the cost, the expense of court and going to trial. And then we're talking about governing law. What law do we want to apply? In our precedent here, we're using California, but if the company was based in Delaware, we would use Delaware, and there are reasons for that. There's also severability. If any of the provision in the agreement is held to be invalid, the whole agreement is not necessarily invalid. Successors and assigns. Let's say the brand is sold. Somebody buys the brand, a larger company, and this brand had a contract with this manufacturer. Maybe the buyer of that brand bought that brand because of the deal terms they were getting with the manufacturer. Does that contract then succeed over to the new buyer? So there are a number of provisions that we're missing here in this ChatGPT agreement, and they're critical, and they can only come come from understanding the specific deal that we're dealing with, and it comes from understanding who's the party that we're representing.
Absolutely. Yeah, Sahil, this is this is a fantastic breakdown and really exposes some of the challenges with depending on AI if you don't know what you're doing. Now, is this a great maybe outline if you're thinking about entering into negotiations, things you might want to think about? But I think given the name of our podcast is Letters of Intent, this could be a great, letter of intent, understanding,
Right.
okay, here are the issues that we need to address. But when it comes to executing a full agreement, there's a lot more that clients, it sounds like there's a lot more that clients need to think about. And you walked us through a lot of important provisions. Another element here that I think I don't want to necessarily leave without addressing is the statement of work.
Yes.
And but that is a critical element to these contracts. ChatGPT just says, include one, but a statement of work really lays out the details of the requirements, of descriptions, testing methods, distinct payment terms. These are usually heavily negotiated as well, elements of a contract. And, we've worked with the very big manufacturers for cosmetics, and we've spent a lot of time just going back and forth on some of the terms in the statement of work. So it sounds like to me, if someone is taking their business seriously, whether they're manufacturing clothes, apparel, or cosmetics, skincare, it sounds like they really want a good manufacturing agreement in place that will protect them and make sure that they understand the deal terms and how they're protected and the risks they have in these agreements.
I think that's right. I would encourage all of our clients to use AI and ChatGPT because it is part of our world and it is a very powerful tool to get a sense of what are things that may be important, like you were mentioning, when it comes to just understanding what could be questions that you need to ask. But when it comes time to drafting a complex agreement that has a lot of money at stake and a lot of risk at stake, you need battle-tested precedents and you need some battle-tested attorneys who know what's going to work and what can go wrong.
I think that is well put, and I think a great place to end, Sahil. So thank you so much for walking us through these contracts. I think you did a great job of really breaking down the nuances of these agreements and things for clients to look out for. This is super helpful. I know I learned a lot too, just hearing you go through it. So thank you so much, Sahil. And this is Letters of Intent, a special episode on breaking down contracts that you may be needing in your business. Until next time, please like, follow, share, and stay tuned for future episodes.